Hello, hello. Welcome to Crime in Court. My name is Heather, and this is part four of the Idaho Four's motion to change venue. So, we are talking about Idaho 4 University of Idaho homicides, the quadruple homicides of Kaylee Gonzalez, Madison Mogan, Zana Kernodle, and Ethan Chapin. And Bryan Kohberger, as we all know, is the suspect that is going to be going to trial sometime next, I think it's June. I can't remember, but it's next year, next summertime. And sorry, here I am. So Ann Taylor, that was Ann Taylor, that was on the thumbnail. That is his public defender. And she recently put out this motion to change venue because, as we know, Latah County, we've read through this. It's a smaller county. There's only like 30 something thousand people, whereas in a neighboring county, Ada County, it would be, 100,000 people that they would have out of their jury pool to select from. So, and once you start like weeding out people who can't do it, people who are too young, too old, that's not even including just the people that can serve on jury duty. So you have to weed those people out, and then your number's even smaller. So it just makes sense to go to a bigger county. And this motion to change venue, uh, in Taylor, we read through in part one, we read the motion. She lays it out very nicely. In part two, we went through a bunch of the press releases that it was almost like a daily press release coming from the Moscow Police Department. So that was very prejudicial to the jury pool and the neighboring areas because all of this information was going out and getting told, oh, he's a monster and da 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 whatever. So it can all be prejudicial. And then when you have the person in custody, a suspect in custody, the media portrays them as this evil monster, and they're obviously guilty because they've been arrested, even though this country is supposed to be innocent until proven guilty in a court of law. But yet, we all convict people way before their actual conviction, which we need to get out of the habit of doing. And with my channel, I hope that we can learn how not to prejudge people just because they've been arrested. So, anyways, with that being said, I'm going to lead into part four. Well, part three, we continued on with press releases and we started reading Dr. Amani L. Ayali. I don't know if I'm saying that right, but something along those lines. I'm going to call him Dr. Amani. That's his first name, but I don't know how to say his last name. So Dr. Amani put together this fantastic report. He put together tons of examples of how these things might prejudice, or tons of examples of things that could prejudice a jury or the county. So I'm going to pick up where we left off and I'm going to go over it quickly. I'm not going to go over all of the examples. I'm just going to show you what kind of what he says and then maybe show you like a couple examples. And then we're going to get into his report. We've got pie charts, we've got line graphs. We're going to get into it all. So hit that like button and let's begin. All right. So starting where we left off, I'm going to read just the context and then maybe a couple examples, like I said. So, the Latah County community has come together in support of the victims and their families. For example, there were several candlelight vigils and a memorial created to remember the victims. The home where the homicides occurred was donated to the university and later demolished. So, at this point in time, it had already been demolished. As Dr. Amani writes his report, but as we were reading through the press releases, it was still obviously standing at the time. All right, so multiple groups were created on social media and thousands of posts appeared with the hashtag Vandal Strong. members of the victims' families use the media often as an outlet to remember their lost loved ones and voice their frustrations as a case has moved through the court system. And I'm not criticizing them. I'd be going to the media too because their case, for whatever reason, they feel like the case is not being handled appropriately. They are frustrated with the investigation. They're frustrated with the answers that they're getting from law enforcement, and being the victims of the families, they should kind of feel a little more comforted at this point in time, but no. Anyways, so members of the family use the media as an outlet to remember the loved ones and voice their frustrations. So some examples of this would include like the UI held a candlelight vigil November 30th. Number of students who left campus early. UI has posted a candlelight vigil or postponed, sorry, a candlelight vigil. Stickers will be handed out during a candlelight vigil. Vigil will be simultaneously at 5 p.m. across the university. You get the picture. There's a lot. These are all things that have been, put out there in the public, in the press, in the media, somewhere where it's public viewing. University is also in the process of designing a memorial garden on campus. Why they needed that for like $1 million, I don't know, but why don't you, deal more with safety and prevention, but let's do a garden and get donations. So as you can see, there are many, many things here that could be taken out of, not even out of context, that could be taken by anyone who hears them as something that would bias them going in as a juror. So, like here, the parents of victim Goncalves have consistently vented frustrations about the length of time the case has taken. Da 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 da. So even that is could be prejudicial to law enforcement, right? Because they're saying they're frustrated with how long it's taking law enforcement to solve this case. More than 17 months and counting since Kohberger's arrest to bring to trial. So at that point, they were frustrated with him not going to trial yet, but there were issues, and he had to waive his speedy rights because discovery, and that is one of the biggest tricks prosecutors use to help violate someone's constitutional right to a speedy trial. They neglect to turn over discovery, and then how are you going to defend yourself when you don't have your discovery? So you have to waive your speedy right. And it's a ridiculous game that prosecutors play constantly. Anyways, moving on, the media has also kept this case in the public's consciousness by providing constant updates on court proceedings, no matter how trivial. Exactly. And we read through them all. And some days it was like barely anything new to come out, but it was like, sensational. These hearings have covered a range of topics from the court-imposed gag order to evidentiary disputes. As part of the coverage, the victims' families and the public have been critical and perceived efforts by the defense to delay the trial. What? It's the prosecution trying to delay the trial, but okay. There was see what I mean? Like the media can go with one story and it just spirals and everybody thinks that. It just becomes like a collective thought that everybody believes. Like, oh, I thought he followed one of them on Instagram or something. That rumor had been going on for a long time after they arrested him. There was also no significant coverage surrounding the defense's change of venue survey, which came to light after the government filed an unsealed motion to stop the data collection process. So nobody even was talking about the survey until the state was like, hey, why are you doing this? This resulted in another deluge of prejudicial coverage and discussion on social media and YouTube after two hearings were streamed on Court TV and watched by thousands. We watched it here too. The media drew on the prosecution's court filing and arguments during the live streamed proceedings, accusing the defense of spreading misinformation. And that's something prosecutors love to do. They love to accuse the defense attorneys of spreading misinformation about their cases because it hurts their case. If the defense comes out and says, my client's innocent and we have proof, blah, 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 it's going to come to light. They don't like that. Prosecutors don't like that. So they just say, oh, you're just spreading misinformation. You're just lying to everybody, to the public and the court, which is kind of a bold accusation to be lying to the court. This coverage fed the public perception that the defense was trying to undermine the judicial process or get Kohberger off on a legal technicality, and which drives me crazy. People don't get off on technicalities, they get off for good reasons. And a technicality is a good reason. Technically, the investigators botched the investigation and didn't do a good job. So technically, you should throw the case out because you can't prove that I did it. Technically. See the technically? All right. Anyways, this resulted in a deluge of prejudicial coverage. The discussion on social media and YouTube after the hearings was watched by thousands. Media drew on the prosecution's court filing and arguments during the live stream proceedings, accusing the defense of spreading misinformation and tainting the jury pool. This coverage fed the public perception that the defense was trying to undermine the judicial process or get Kohberger off on a legal technicality. I read this already, I'm so sorry. And further undermined the court's efforts to stem the flow of information to prospective jurors. Examples of this media include, for example, the prosecutor Bill Thompson said the questions on the survey were completely inappropriate for potential jurors and that the information in the question was false and inadmissible, and that the questions violated the non-dissemination order. So those are supposed, um, those are things that Bill Thompson said, accusing the defense of changing the jury pool by asking these completely inappropriate questions, things that are false and inadmissible, blah, blah, blah. People hear that and they're like, oh, the prosecutor said that? The defense is doing that? Oh, well, the prosecutor's not going to lie. So obviously, the defense is in the wrong because that's how a lot of people in this nation think. And it's so scary. Other things like Bill Thompson argued the survey is violating the court's non-dissemination order. He said, this is reckless conduct and it's outrageous." Those are outrageous words. He's trying to incite some kind of emotion by being so dramatic. Hold on one second. All right. So Thompson accused Edelman's survey of including loaded questions. Thompson said it seems the defense is okay with tainting the jurors to ascertain the bias of all potential jurors. See how his words could be, I mean, they're almost like defamatory, but it's okay. He's allowed to say that in the court of law, to just blatantly call these things, to like basically accuse the defense of like some kind of misconduct or whatnot. And that's all right. It's allowed for some reason. Defense attorney and judge in the Bryan Kohberger case participated in a heated argument Thursday regarding due process and a survey. So that's the basically making it seem like they got into a huge fight, which they didn't. They got to dramatize, dramatize everything. All right, so let's move on. There are several examples. In conclusion, my review of the pretrial publicity indicates that the Latah County jury pool has been saturated with prejudicial coverage surrounding the sensational homicides of 4 University of Idaho students, the ensuing search for the unaliver, public statements from the victims' families, and evidentiary details after Bryan Kohberger's arrest. The media reported extensively on alleged evidence, some of which proved to be false or misleading. The homicides sent shockwaves through the local community and generated a state of panic. Between 25 to 40% of the student body failed to return to Moscow after the Thanksgiving break. So that would have been maybe like 2 weeks or so after the homicides occurred. People did not come back. Before the defendant's arrest, there was widespread frustration with the lack of details made public about the ongoing investigation. So people were already, before Bryan Kohberger, people were already annoyed with law enforcement because law enforcement wasn't getting answers to the people in a timely manner. They weren't getting the right answers. They weren't answering the people's questions. And people wanted justice. With minimal official information available, rumors, speculation, and misinformation proliferated. And it absolutely has gone nationwide, if not worldwide. All right, so the survey data indicate that the media coverage has negatively impacted the Latah County jury pool. For example, 98% of the Latah County survey respondents have read, seen, or heard about the case, and 86% recognized at least 4 of 9 media items tested in the survey. 81% of those familiar with the case have read, seen, or heard the police found a knife sheath on the bed next to one of the victims, and 67% heard that DNA found on the sheath matched Bryan Kohberger. So that's pretty huge. I mean, those are pretty big numbers. That means that whatever kind of PR campaign, the smear campaign that police begin, once they begin an investigation, they're going to potentially taint the jury pool by putting out different facts and things that might not always be entirely accurate, especially early on in the investigation when they don't know all the facts. Anyways, all right, so 67% heard that the DNA found on the sheath matched Bryan Kohberger. In addition, 88% of Latah County survey respondents have talked about this case or heard others talking about it in person or online. The media coverage has also shifted the burden of proof to the defendant. So basically, yes, the media, with all the coverage that they've been doing on it, even before Bryan Kohberger was the one that was the suspect, that the face that we have picked for this case, whoever was going to be in that seat was going to be vilified and presumed guilty before anybody could ever even have a chance at a trial. So, many community members exposed to prejudicial media coverage hold a presumption of guilt in this case. 67% of survey respondents familiar with the case believe that Bryan Kohberger is guilty, and 51 reported that he would have a difficult time convincing them otherwise. Telephone survey. A telephone survey was conducted in Latah County. Comparison surveys were conducted in Ada, Canyon, and Bannock counties. Research Strategies Inc., which is based in Mobile, Alabama, was hired to field the telephone survey. Standard why can't I say the word? That doesn't sound right. Standard practices, standard methods of practice related to the development of the instrument, interviewer, training, sampling, and callbacks were closely followed. The survey instrument and methodology adhere to the professional standards and guidelines put forth by the American Society of Trial Consultants. All recognition questions were designed to describe the case using the language found in the media coverage. The surveys were in the field between March 5th through July 6th of 2024. The survey can be found in Appendix B, and we'll look at it. Ultimately, 400 non-jury residents in Latah County, 400 in Ada County, 200 from Canyon County, and 202 from Bannock County completed the survey. Case recognition. It is my opinion that the results of the telephone survey indicate that there is bias in the Latah County jury pool against the defendant stemming from exposure to pretrial publicity. Sensational crimes are more likely to have a longer lasting impact on the public's consciousness in smaller communities. So it's going to last longer because of the size of the community. They've been um it's harder and it's more difficult. It takes longer to heal from those supposed any traumatic event, like even a tornado or something comes through your town. If you're a large population, like the city of Chicago, it's not necessarily as big of a deal as if it was like some little tiny town in the middle of the Illinois cornfield that gets hit by a tornado. So it's just very different. Where were we? Sorry. In addition, informal communication channels, including social media, can have a greater effect in spreading rumors and misinformation about a sensational crime such as this. Latah County is the 11th largest county in Idaho with just 32,515 residents over the age of 18. 66%, or 21,598 of its jury-eligible population reside in Moscow, the community most traumatized by the crime. So, the overwhelming majority of the people live in Moscow, the town that it happened in. So that can't be like it's it's not a good idea to have most of your jurors coming from the same town that, where there could be family ties and, relations, connections. You don't want to get into all of that. Latah County residents have remained highly invested in this case despite the passage of time. Almost all 98% jury eligible respondents were familiar with this case. In addition, approximately 68% of survey respondents reported that they have followed the case somewhat or very closely, with 29% falling into the latter category. So 29% saying very closely. Presumption of guilt. The survey data also indicate that the presumption of innocence has been shifted to a presumption of guilt. Approximately 67% of prospective jurors who were familiar with the case believe Bryan Kohberger is guilty of homicide, with 25% falling into the definitely guilty category. The presumption of guilt increased to 81% for those who recognized 7 or more media items tested in the survey. Furthermore, 51% of those who had been exposed to media coverage reported that Kohberger would have a difficult time convincing them that he was not guilty, which increased to 66% for those recognized 7 or more for those who recognized 7 or more media items. Just 19% reported that the defendant would not have a difficult time convincing them of his innocence. So, in comparison, less than 20% say they could be convinced of his innocence, but that's about it. All right, so uh, as for sentencing, 52% of Latah County survey respondents believe the jury should sentence Kohberger to DP if he is convicted, compared to 24% who favor life without the possibility of parole. Approximately 51% of those who did not support a life sentence indicated that the defendant would have a difficult time convincing them that he should not be executed. Only 19% disagreed with that statement. Case knowledge: community members have more than just a passing familiarity with this case. Approximately 79% of Latah County survey respondents recognized at least 5 of 9 media items tested in the survey, and 52% were familiar with 7 or more. That's a lot. 81% of survey respondents who recognized the case had read, seen, or heard that police found a knife sheath on the bed next to the victims, and 67% were aware that the DNA found on the knife sheath was matched to Bryan Kohberger. In addition, 86% of Latah County survey respondents heard that the defendant owns the same type of vehicle recorded on video, driving in the neighborhood where the homicides occurred. So supposedly he's on video. 86% said of Latah County respondents thought that he is seen on video. 79% were aware that cell phone tower data purportedly show that Kohberger made several trips near the victim's home months before the homicides. Familiarity with such incriminating details, which came from the probable cause affidavit shared with the media, is particularly concerning, given that most were significantly related to prejudgment. For example, 75% of Latah County survey respondents who had read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger believe he is guilty of homicide, and 60% indicated that he would have a difficult time convincing them otherwise. All the media items tested in the survey and significantly related to the presumption of guilt are provided in the table below. Some of the most prejudicial media items were those regarding misinformation. For example, 81% of prospective jurors who had heard that Kohberger stalked one of the victims reported that he is guilty, and 62% maintained that he would have a difficult time changing their minds. Again, an overwhelming majority is saying, I don't think I can be convinced that he's innocent. Only after this allegation was proliferated through the media and social media for 16 months did the prosecutor clarify in the April 2024 hearing that it was untrue. I didn't even know that he did that. So I must have seen it because I probably streamed it. I don't remember him saying that. I don't remember the prosecutor ever coming forth and clarifying anything that was said in the past that has been untrue, like him stalking a victim. Prospective jurors, and that's the problem. Like, we've all heard that he's rumored to have stalked a victim, but we've never heard that the prosecutor actually said, oh, wait, no, that's not true. We never heard him denounce that fact. So that's a problem. That's what I'm saying, is like we all hear the bad stuff, and then when it's corrected, we don't hear the correction. Prospective jurors who have seen media coverage discussing Kohberger's alibi have also reacted critically. Approximately 79% of those who read, seen, or heard that the defendant said he was driving alone on the night of the homicides believe that he is guilty. What is with all these people just convicting him before he even has a say? Like, he's remained silent the entire time. We haven't heard a word from him. Yet everybody believes that he's guilty. And there's been nothing that I've seen, not in the probable cause or any of the filings thereafter, that make me believe that Bryan is probably, I mean, I don't believe that there was probable cause for Bryan. And there's nothing that makes that connection for me. Like, here's the University of Idaho students, here's Bryan. They're in two different worlds, and all of a sudden, now they're colliding, and I'm supposed to believe this Bryan just went there for what? No reason. Randomly. I don't know. Maybe. Could be. But show me the proof. I'm just not there. And I know we're not at trial yet, and that's fine. So I'm just telling you, I have not made up my mind, and I won't until trial. And I don't know why everybody does. 62% indicated that he would have a difficult time convincing them that he was innocent. All right, so this is pretty much the questions. So, have you read, seen, or heard that Bryan Kohberger stalked one of the victims? 81% said they believe he's guilty. 62% said the defendant would have a difficult time convincing them that he was not guilty. I don't want to read through all of these, but Bryan Kohberger said that he was out driving alone, 79% versus a 69%. Believe he's guilty versus would have a difficult time convincing. So I don't have to keep saying that. All right, so people have read, seen, or heard that Bryan Kohberger followed one or more of the victims on social media. Again, it's like the same split, 80% versus 62%. They're dead set in their beliefs that he is the guilty party. Bryan Kohberger said that he was driving alone. We got that. Bryan Kohberger had followed one on social media. DNA found on the knife sheath was later matched to Bryan. That's 75% to 60%. It's still right around 75, 80%. University students in Moscow and their parents lived in fear until Bryan was arrested. That's an interesting question. 74% versus 56%, still right around that same split, but a little bit more reservation, I think, on that question. All right, so police, but I've never heard that everybody was living in fear, although kind of, I guess you could take from the press releases that everyone was fearful because they made it seem that way in those press releases. Anyways, police found a knife sheath on the bed next to one of the victims, 72% to 55%. Bryan Kohberger owns the same type of car recorded on video driving in the neighborhood where the homicides occurred. That's again, now we're like getting lower here, but 72%, 55%. And cell phone tower data show that Bryan Kohberger made several trips near the victim's home in the months before, 72 to 55%. So, consistent with what often happens in smaller venues, rumors, conjecture, and misinformation have spread through informal discussion and alternate communication networks, such as social media. Approximately 88% of Latah County survey respondents who recognized the case have talked about the homicides or heard others talking about them in person or online. Prospective jurors were also familiar with misinformation reported in the media and tested in the survey. For example, 45% have read, seen, or heard that Bryan Kohberger stalked one of the victims. 45% were aware that he allegedly followed one of the victims on social media. Earlier in the survey, respondents were asked what rumors or theories they had heard about the homicides, the defendant, or the victims. Latah County survey respondents reported a litany of rumors and conjecture that have been spread in the coverage, informal discussions, and social media. And here's some examples. He may come from a family of crime, and previous cases have been uncovered. I've heard that Kohberger has been linked to other homicides in Washington and Pennsylvania. I've heard they are railroading Kohberger to put him away, and the evidence was planted and he was being framed. One other one that I heard was that, so this is on social media. One other one that I heard was that he was working with one of the other of the roommates, one or the other, with one or the other of the roommates. What? With one of the victims, maybe, or one of the roommates, is what they might be trying to say. Speculation that Kohberger committed a homicide in Oregon. Okay. The house was a party house, and a couple of people lost their lives there, and they weren't supposed to be there. The boyfriend and the girlfriend, also Kohberger, had commented about committing the perfect homicide in a paper. So people talk about his like studies, his wanting to be in criminology as part of like his motive, or they use things that he's done, like surveys, they use things against him. News on the street, it was really gruesome and vicious. Also heard by some people I know in jail that have told me that they have seen interaction with police and Kohberger while in jail and says that police have seemed to be friendly to, butter up to, with Kohberger to try and get him to talk. Police here are doing an excellent job here and on this case. Okay, if you think so. We were told he sliced and diced them and hung them from the fan. That one I have not heard. So, yeah, I'm not going to keep reading these, but you get the point. You get the point. They're very sensational. I'm going to put a link to this document if you want to read through the all the samples. You can click on the link in the um, description of the video and you can follow along with the PDF or read it on your own. Come back to the spots that I skipped through. All right, so impact on the community. This crime has a devastating impact on Latah County residents, many of whom considered this to be a very safe and close knit community prior to the homicides. More than half, 56% of survey respondents reported that they or someone they know experienced high levels of stress, anxiety, and fear during the search for the unaliver. The number increased to 63% for Moscow residents. Another 40% of prospective jurors have visited or walked by the home where the homicides occurred. The University of Idaho plays an important role in Latah County and the local economy. Its 9,493 students and 2,321 full time employees compose 36% of the county's population over the age of 18. That's huge. As such, the exodus of students after the Thanksgiving break had a significant impact on local businesses. Approximately 78% of Latah County survey respondents reported that they or someone they know lived in Moscow at the time of the homicides. In addition, 25% reported that they or a family member was a student or employee at the University of Idaho in Moscow. Latah County survey respondents were asked how the homicides impacted their community. Many reported that the environment was very tense and everyone was on edge. Residents were on high alert and living in a state of fear. For the first time, people were locking their doors. And like I said in the last stream, lock your doors, people. I don't care how big or small a town you live in, lock your doors, be safe, protect yourselves. Parents feared, get a dog, get a big dog. Parents feared for their children's lives. The sudden student exodus hurt local businesses. Others complained about the influx of media and reporters into Moscow. Survey respondents described the personal fear that they and their neighbors experienced while the unaliver remained at large. Some of the things that they were saying was, I think, tremendously basically changed everyone's lives, a community that felt extremely safe, caring, personable, changed in an instant. I don't know how long it'll take the college students to feel safe again. It's so terrible. It jarred the whole community. It has ripped us in a very negative way. It ripped our community apart. We lived in fear for so long. I know I still do. We felt a deep loss and broke all our hearts. Dark cloud over the community for so long. The fear we faced will forever change our community forever. So you get the point. Hopefully, like I said, you can come and look at this on your own to look at all the many, many, many examples that they provide in this document. All right, so community pressure to convict Bryan Kohberger, as demonstrated in answers to several of the open-ended questions. Many Latah County residents expressed a self of relief after the defendant was arrested. Survey which is crazy because just because you think someone's arrested doesn't necessarily mean that it's the guy or that it was the only person. I'm not saying he's innocent. I'm not saying anything. He might have done it, and maybe somebody else was involved too. Who knows? Survey respondents were asked how they believed residents in their county would react in the jury if the jury acquitted Bryan Kohberger. Latah County survey respondents' answers indicate that a local jury will be under tremendous pressure to convict so that the community can begin to heal and recover the sense of safety that was lost. I'm going to rewind and read that again. A local jury will be under tremendous pressure to convict so that the community can begin to heal and recover the sense of safety that was lost. And that's huge. Even if there are so many reasons for doubt in a trial, a jury might feel so much pressure because a case is so huge that they tend to convict because they don't want the public mad at them. And because they're like, okay, well, the public all sees it, so I'm gonna, I see it too. I'm gonna look for the things that make the person look guilty if, in fact, that's what some of them do. I mean, it's your confirmation bias. So you're picking out the parts of the testimony that, I mean, we all do it, but if you're persuaded one way or another, it's not, you can't do it while you're on a jury, but we all do. Anyways. All right, so many survey respondents reported that an acquittal would lead to an uproar and put residents back into a state of fear knowing that the unaliver was free. Others reported that Bryan Kohberger would be himself unalived if he was acquitted. That's a very scary thought, that the town is so outraged that somebody would take his life. That's pretty scary. Some said the community would place blame on the local prosecutor and law enforcement if there was a not guilty verdict. So meaning if they didn't get the guy, they didn't get a conviction on this guy, then they would blame law enforcement and the prosecutor. Survey respondents also reported that the defendant, my tongue gets tied, sorry. Survey respondents also reported that the defendant would have to present evidence to convince the community that he was not guilty. So again, burden shifting. These comments reinforce the quantitative data which show a strong presumption of guilt in Latah County. Examples of these types of reactions to a hypothetical acquittal include they'd burn the courthouse down. Outrage would be a mild description. These are examples of reactions if he got a not guilty, what the town people would do. Be very upset. They would think the jury failed. I think we would all be heartbroken all over again. And fear would probably rise in us again. I don't think we would be okay with a not guilty verdict at all. I Sorry, I snorted. I would be very hard. It would be very hard for our community to accept, and it would be very difficult for us to move forward and feel safe in a community. So you'd rather convict somebody, even if they're the wrong person, than to go about it the right way and get the right person. Wow. That's what I don't understand. How can anybody live with themselves putting away innocent people? I just don't get it. And these prosecutors, I don't understand how they sleep at night. Some of them. They better have substantial evidence to not convict, and people would be fine if that was the case. Oh, okay. If he is not guilty, prove it. Burden shifting. They will have to prove the real evidence and that he's not involved in the homicide. They proved that he's not guilty. They'd have to find somebody else because somebody took the lives of those kids. Yeah, right, exactly. So if they prove or if it's proven that Bryan Kohberger is not guilty in a court of law, then they're going to have to go after somebody else. So that's a very scary thought for the community to be at. I can't imagine that happening because they have so much against him. We would be dumbfounded. This person would be angry and shocked. I think they should try him right here. Okay. Riots. Parents will take care of him. Okay, there are a lot here, and I'm going to skip through them. All right, comparison surveys. The comparison surveys also found significant case recognition and prejudgment in other potential venues. Cannon Canyon County is the second most populated county in Idaho with 1,800 and with 184,000 residents. I don't know what I said. 184,000 residents over the age of 18. Approximately 90% of the jury eligible population there had read, seen, or heard about the case, and 51 followed the case somewhat or very closely. 69% of Canyon County survey respondents believe Bryan Kohberger is guilty. So the numbers are less. 90% have still heard about the case, though, which is probably, you can't avoid it. I mean, you can probably ask a small town in, I don't know, North Carolina, have you heard about this case? And they'd probably say 90% have, because it's a big nationwide case now. But yes, but you can see the numbers are kind of smaller, kind of. Um, where did I leave off? In addition, 57% of those familiar with the case believe the defendant should be sentenced to and get the DP, and 59% indicated that he would have a difficult time convincing them that that he should not be executed. The Bannock County Courthouse is 532 miles from Moscow, so it's not really a good option, but it's an option. It is in a different media zone and was exposed to less coverage about the homicides. Approximately 84% have actually recognized the case, some 14 percentage points lower than Latah County. Just 45% of survey respondents followed the case somewhat or very closely, and 59% were familiar with five or more of the media items tested. However, 76% of those familiar with the case believe Kohberger is guilty of the homicide, and 53% of those individuals reported that he would have a difficult time to convince them otherwise. In addition, 53% believe the jury should sentence Kohberger to D, and 50% maintained that the defense would have a difficult time persuading them that he should receive a life sentence instead of the DP. These data show that there are differences across venues in Idaho, for sure. However, Bannock is a small county with just 66,000 residents over the age of 18. In addition, like Moscow, it has a large university that plays an important role in the local community. Idaho State University's student body makes up 18% of the county's population and is the second largest employer. Given Bannock County's size and similarities to Latah County, it is likely that the local jury pool would be inundated with media coverage if the case were to be transferred there. So it's not really a great option. Ada County is the largest in Idaho with, oh, I was wrong. It has 406,000 residents. I thought it was 100. It's 406,000 residents over the age of 18. Its population is more than 12 times larger than Latah County. While Boise State University is in Ada County, its student body of 22,000 students compose just 5% of the population over the age of 18. Ada County was also exposed to significant media coverage surrounding this case, which is reflected in the 93% recognition rate. In addition, the prejudgment rate, 68%, mirrored that which was found among Latah County's survey respondents. Approximately 56% reported that Kohberger would have a difficult time convincing them that he is not guilty. In addition, 49% of Ada County survey respondents who recognized the case believe that Kohberger should receive the DP, and 55% maintained that they would have a difficult time convincing him otherwise or them otherwise. However, there were important differences between the Latah and Ada County jury pools. Ada County residents are far less invested in this case. Only 15% reported that they followed the case very closely, compared to 29% of prospective jurors in Latah County. They were also less familiar with prejudicial media items. Approximately 63% had read, seen, or heard that police found a knife sheath on one of the victims' beds, compared to 81% of Latah County. In addition, 52% had heard that DNA on the knife sheath matched the defendant, 15% points lower than Latah County. Because what was it, like 62%? Ada County survey respondents were also less familiar with prejudicial information reported in the media. For example, 35% had heard that Kohberger allegedly followed one of the victims on social media, as opposed to whatever it was. um, in Latah. Ada County residents had fewer personal connections to the case and Moscow community. Only 20% lived in or knew someone who lived in Moscow when the homicides occurred. Just 4% reported that they or a family member was a student or employee at the university there. In addition, only 2% of survey respondents are employed or know someone employed by a law enforcement agency involved in the investigation. Finally, Ada County residents did not experience the degree of emotional distress during the 6-week search for the unaliver, which was found in Latah County. Approximately 31% reported that they or someone they know experienced high levels of stress, anxiety, or fear before Kohberger was arrested, 25% points lower than in Latah County. So that's a huge difference. That fear level is going to be a huge difference in how people interpret going into a case, going in as a juror. The ability to select a fair and impartial jury in venues saturated with media coverage. Excuse me. Hold on one second. All right. When a jury pool has been exposed to prejudicial media coverage, the trial court and parties are faced with unique challenges which are not present in most cases. In high-profile cases, many prospective jurors enter the courtroom with extensive knowledge and attitudes about the case, the defendants, and the victims. However, it is often difficult for prospective jurors to predict how case-specific knowledge and opinions may affect them over the course of a trial. Prospective jurors may also unintentionally omit exposure to specific media items during voir dire when asked what they recall hearing about the case. These items, however, may become salient and recalled from memory once witness testimony begins. The search also shows that the information learned from media exposure can be misattributed as evidence presented at trial. That is true. So some of the things that come out can also be like the ring camera footage that was reported um, regarding Karen Reed hitting John O'Keefe. One of the news stations reported that there was actual ring video footage of her doing so, and it never came out in trial. But people still think that this footage still exists, but it didn't come out at trial. Okay, that would be the first thing the prosecution would play in their opening statement, but never mind. What do I know? Given these factors, it is important to ferret out during voir dire the full extent of exposure to pretrial publicity, case-specific attitudes, impressions on the defendant, and potential motivations to serve. However, the prejudicial effects of pre-existing attitudes can occur at both a conscious and subconscious level, meaning jurors who profess impartiality may not be fully aware of their bias or how it may affect them as the trial unfolds. So like I've talked about before, we all have biases. You're grown up or you are born into a family. They already have values and beliefs and ways of thinking and feeling, and you pick up on all of that. You take it in, it becomes part of your identity. usually. Or you decide at some point, that's not my identity, and I'm going to identify with this. So we all have these biases, and it's our job to filter through them throughout life and to not be constantly prejudging things. We should look at things more objectively and without our own biases. But the problem is they're ingrained in you from childhood, a lot of them. So you don't always know that they're there. Maybe you grew up in a household where they didn't like spicy foods, hated eating spicy foods. So you thought that you too didn't like spicy foods. And then one day you're an adult, you go out, you eat something that's got some spice to it, and you're like, holy cow, I love this. This is the greatest thing ever. You now like spicy food. When you have a bias, you don't always know that you have it until you realize it. So it's really hard to pinpoint these things and to not to pinpoint it necessarily, but to explain it better. I don't know. All right, so where was I? The prejudicial effects of pre-existing attitudes can occur at both a conscious and subconscious level, meaning jurors who profess impartiality may not be fully aware of their bias or how it may affect them as the trial unfolds. This can make it difficult to identify potential prejudice during the jury selection process. The Supreme Court has recognized the limitations of the voir dire process as a remedy where potentially prejudicial pretrial publicity is an issue. Say that 10 times fast. Potentially prejudicial pretrial publicity. Blah, blah, blah. Sorry. In Irwin versus Dowd, the court concluded no doubt each juror was sincere when he said that he would be fair and impartial to petitioner, but the psychological impact requiring such a declaration before one's fellows is often its father. Where so many times admitted prejudice, such a statement of impartiality can be given little weight. As one of the jurors put it, you can't forget what you hear and see. Exactly. Just like when you're at trial and the attorney asks a question and the person gives an answer, and then the court goes, or then the other attorney is like, objection, and the court says sustained, strike that answer, strike it from the record. You still heard it though as a juror, and it's still in your subconscious when you go to make your deliberations. Whether you put a prejudice to it or not consciously, it's still in the back of your mind. Anyways, all right. So with his life at stake, it is not requiring too much that petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion and by a jury other than one in which two-thirds of the members admit before hearing any testimony to possessing a belief in his guilt. Relevant or relevant, I don't even, oh, because relevant's underneath it. I saw relevant. Sorry. Research on voir dire shows that these concerns are justified. Jurors are often reluctant to disclose relevant experiences, relationships, or opinions that may lead to bias, even when pretrial publicity is not an issue. So maybe the case has something to do with someone drinking too much and becoming violent. And maybe you grew up in a house where you saw that. Maybe it wasn't all the time, but you did. And so you kind of put it out of your mind and you didn't really think about it. And then if they're asking you about things like that, you don't really, you don't say, oh, yeah, I'm prejudiced to people drinking and losing control of their emotions because I grew up in a household like that. So, yeah. So those prejudices that we all have, they're just sometimes difficult to pin down in voir dire, is what they're saying here. Marshall obtained questionnaires from 277 former jurors in two counties and found that 18% of those jurors admitted to withholding information during voir dire. So a lot of people don't tell you everything. Seltzer reported that approximately 39% of jurors who were interviewed after trial should have come forward in response to questions regarding crime, victimization, or knowledge of police officers during jury selection, but failed to do so. That's 39%. That's huge. Many aspects of the large group voir dire format deter juror candor. So federal court judge Gregory Mize published his findings after experimenting with an expanded voir dire procedure in 30 federal criminal trials after a 9-month period, which included individual interviews with every veneer member who failed to respond to his general opening questions. Judge Mize reported that approximately 28% of members of each panel failed to respond to the dozens of questions posed in open court, an average of about 16 people per trial. However, when questioned in private, 1 in 5 of these silent jurors disclosed personal information that was relevant to the case. So it is a question about being in a public versus a private setting and not wanting to disclose things in a public setting, which I don't blame them in an open session because voir dire usually is open to the public. So even though they don't televise it usually, but you as a member of the community can go and sit there and watch it. However, when questioned in private, 1 in 5 of these silent jurors disclosed personal information that was relevant to the case. In 90% of the trials, between 1 and 4 of these silent jurors expressed bias that led to their removal for cause. A search of appellate opinions shows that juror disclosure has led to several mistrials by undermining a defendant's fair trial rights. So, this could be a big deal if they continue down the path of we're going to continue this in Latah County. That could be a huge appealable issue because I mean this it's I think it's going to be difficult for the judge to potentially deny this because they've really done the research, they've laid it out, they've put it out there. But who knows? Who knows what the judge? Maybe he wants something more or different. I can't, ever think ever understand what a judge is thinking. But in this case, we shall see if he decides that we can move it to a new venue. Um, what was I was going to say something else. By not moving it, what I was going to say something and I totally lost it. Never mind. All right. So, for example, in U.S. versus Colombo, a juror failed to disclose when asked during voir dire that her brother in law was a lawyer for the government. She did not mention this fact because she wanted to sit on the jury for the case. So, she just lied because she wanted to be on the jury. In Dyer versus Calderon, a juror answered no when the panel was asked if anyone had ever been the victim of a crime. After the guilt phase, the defense learned that her brother had been shot and his life taken 6 years earlier. When questioned, she told the judge that she answered no because she thought the shooting was an accident, not a crime. Her brother had been pistol whipped 4 times and shot in the back of the head. Was that not a crime? All right, so problems such as these also have been reported in high profile cases. For example, in the 2012 trial of Matthew Stebbins, who had been charged in a shooting of at a homeless shelter, a mistrial was declared after juror announced during deliberations that she had a previous issue with violent crime. One of her children had been shot in the head. She failed to raise her hand during jury selection when asked if anyone had been a victim of a violent crime. According to her, she did not think it was going to be an issue. Okay. A $6.5 million judgment was overturned in the high profile police corruption lawsuit against the public defender surrounding the Rampart Division in Los Angeles County. It was uncovered after the verdict that one of the jurors, Jennifer Salinas, had concealed knowledge of the scandal during jury selection. She did not raise her hand when asked if anyone had some knowledge of events surrounding the Rampart Division. Later, it was discovered that Salinas had played a prominent role in the movie titled Gang Wars with a Z that was based on the Rampart Division. I've never heard of that movie. Other jurors on the panel corroborated that she was very familiar with the scandal and discussed aspects that were not in the evidence. So, other jurors knew and didn't report her. That's also problematic. Prospective jurors who have been exposed to prejudicial pretrial publicity enter the courtroom with case specific knowledge gleaned from the media, social media, and discussions with friends, family members, and coworkers. Uncovering the full extent of jurors' case specific knowledge and opinions in high profile cases can be extremely difficult. Jury selection as a judicial remedy to address such bias relies on two factors. One, that jurors can access their source of bias, and two, and that means like they know that they're biased, but a lot of times, like we said, they don't even know, or they might not care. And two, are willing to report it. So you have to be conscious and aware of your bias, and you also have to be honest about it when you disclose your information during jury voir dire. So, in one study where researchers tested the effectiveness of extended voir dire, participants in the experimental condition were exposed to pretrial publicity a week before the experiment. Prior to viewing a trial, they were subjected to minimal or extended voir dire. The attorney in the extended voir dire condition explained how pretrial publicity may inappropriately impact decision making, asked jurors to hold each other accountable for not discussing pretrial publicity, obtained public commitments to base their verdicts solely on the evidence presented in court, and to ensure that fellow jurors did the same. The researchers ultimately found that educating jurors on the potential impact of pretrial publicity did not eliminate the effects of pretrial publicity. So just knowing about it, educating them about it, doesn't prevent it, doesn't stop it. High profile cases also create a unique challenge during jury selection known as the maximization effect. This effect refers to prospective jurors' attempts to minimize the full extent of their exposure to pretrial publicity. During voir dire, prospective jurors try to downplay their knowledge of their case using qualifiers such as just, nothing other than, only, a little bit, and that's all. Like, I only saw this one article, or I only saw 5 articles on it. In an archival study that analyzed the jury selection transcripts from 5 high profile cases, 69% of prospective jurors used minimization language when questioned by the judge or attorneys. Because, like, you feel you're also like on an interview and you want to be on your best behavior. So you want to like give the right answers. you know, you feel like you should give them the answers that they want to hear. Another challenge in cases with significant media coverage surrounds the difficulty jurors have during voir dire process to recall every detail that they have read, seen, or heard about. So that's the other thing. They could forget that they even saw an article, but then later, something in the trial, they're sitting there on jury duty and it triggers something that they heard, triggers a memory, that they read this article back way back when. For example, if someone is asked to recall everything they know about a movie, Star Wars, their description would likely miss important details that they're familiar with. Memory is much more accurate when answering recognition questions, Have you read, seen, or heard if Darth Vader was Luke Skywalker's father? So specific questions. The concern is not mere speculation. In a 2017 change of venue hearing in Texas, community residents exposed to detailed pretrial publicity over 7 years were called as witnesses. Holy cow. During the hearing, they were asked to recall everything they knew about the case. Following the recall question, they were asked a number of recognition questions about specific prejudicial and potentially inadmissible media items they failed to mention. The hearing demonstrated the limitations in their memories. So, question: can you tell the court the facts that you know about the state of Texas versus John Feet as it relates to Irene Garza? Answer: description of facts. Question: is that it? Answer: let's see, I believe so. Question: now, Ms. Perez, have you read, seen, or heard about John Feet giving a confession to a priest? Yes. So I'm assuming in her original answer, she did not say that she heard that. So this is pointing out that, okay, she gave a brief description of the facts of the case, blah, 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 did this to blah, blah, blah. And this was the result. Okay. So is that it? Is that all you know? Yeah, let's see. I believe so. And now, Miss Perez, what else? Have you read, seen, or heard that John specifically gave a confession to a priest? Oh, yeah, I did hear that. Why didn't you tell me that in the first place? So you leave out specific details when you describe your memories of something. You're not going to remember everything. Question: and you didn't mention that a few minutes ago. Answer: I'm sorry, there were two that I remember. They mentioned that there were two confessions that he made to two priests. Question: okay, have you read, seen, or heard about whether or not Ms. Irene Garza was alleged to have been AR'd? Answer: I read, yes. Question: now, having refreshed your memory a few minutes ago, are there any other facts that you have read, seen, or heard that you haven't told the court about? Answer: I don't believe so. Question: okay, have you read, seen, or heard that John Feet was transferred to a monastery after this? Answer: I did read that, yes. Just proving, again, that there are more and more details that are coming out that this person didn't disclose immediately. And you don't, it's not like they're trying to be deceitful, they just don't think of it. Or it's not an important detail to them. But then when they're asked about it, they're like, oh, yeah, I did hear that. "Mhm. Yeah, I read something about that. Sure." So, this limitation in memory recall has been demonstrated in several high profile cases around the country. For example, in a change of venue survey in Sonora, California, 95% of survey respondents recognized at least one additional detail reported in the media from the close ended recognition questions that they failed to mention in the open ended recall question. So, at least one detail. A near identical trend, 96%, was found in another high profile case in Nashville, Tennessee. For example, when asked, what have you read, seen, or heard about the case? One respondent answered bits and pieces of the news. They were just talking about the case. However, he later recognized several media items, including that one, the shooting was captured on video by surveillance cameras in the area and played on the television, news, and internet. That's kind of big. Two, the public approved a ballot measure in the last election to create a community oversight board to monitor the Metro Nashville Police Department. Both were prejudicial items. Yeah, I'd say so. Widely reported in the media. A similar pattern, but he just saw a few bits and pieces here and there. That's what he said. A similar pattern was found in this case. When asked what they have read, seen, or heard about in this case, Latah County survey respondents reported an average of just 1.6 details. However, 96% of survey respondents later recognized at least one additional media item that they failed to mention in their open ended answer and recognized on an average of 4.9 additional media items. So they reported 1.6, but on average, they actually recognized 4.9. That's a big difference. Many survey respondents used minimization language or incomplete responses when asked what they knew about the case. Most of these prospective jurors later recognized items widely reported in the media and tested in the survey. See table below. For example, just 8% of Latah County survey respondents mentioned the police found a knife sheath near one of the victims. When asked the standard open ended recall question, however, 81% later recognized this media item when asked. So, wait, only 8% of the survey respondents mentioned it, but 81% knew about it. That's huge. See what I mean? Like it just wasn't a crucial fact in their mind when they were coming around and saying, like, this is the facts that I know about the case. And then, oh, yeah, I knew that too. Like, what? You didn't say that. But yeah, 81% knew about the sheath. This finding is particularly concerning given that 72% of survey respondents familiar with the media item believe that Kohberger is guilty of homicide, and 55% reported that he would have a difficult time convincing them otherwise. So, this right here means that even if you called in people from Latah County and voir dired them, went through the voir dire process, they might not be telling you all the information. They might not be truthful. They might not be um, remembering everything correctly. Their memory recall might be a little difficult to recall all the facts, but then when you throw the facts at them, they're going to be like, "Oh yes, that, and that I also heard." So I don't know. It's a tricky situation. Tricky situation. Did I start that? A similar pattern was found with other prejudicial media items, some of which were inaccurately reported by the press. For example, only 3% of Latah County survey respondents mentioned that Bryan Kohberger had stalked one of the victims when asked what they knew about the case. However, 45% later recognized this media item when asked, have you read, seen, or heard about it? The failure to recall this detail from memory when responding to an open ended question is concerning given that it is significantly related to bias. Yes. So, a juror, an actual potential juror who walks in there with their jury summons and they sit down and they're saying, oh, here, what potential juror number one, what have you heard about this case? And they say, well, I've heard that the four students were their lives were taken, they were stabbed, whatever. Here's the facts I know. Grubhub driver, whatever. You don't give all the details. There's so many details in this case. How do you give them all? So then when you turn around and ask the juror number one, did you know all of these things? You're going to say, oh, yeah, I did. Because you didn't think about it at first. So here is um, these are the media items that people recognized. So this is how we got the 4.9 average. I'm not going to go through all of them, but like I said, I will give you the link to this document so you can look at it yourself. No, Dexter, go lay down. Dog begs for food all the time. All right, so however, 45% later recognized this media item, which was what? The one about, oh, him stalking the victims. Okay. And then approximately 81% of survey respondents who later recognized this media item believe that Kohberger is guilty. So these are all the questions and answers. Have you read, seen, or heard these things? And their answers are, or what have you read, seen, or heard? These are their answers. Nothing I can think of at the moment, just what has been on TV and the papers. He was arrested and the house has been torn down. That he was arrested so far and they are still working on the trial. So you give like these people are only saying two things and they're very vague. Like they're not saying all these specifics. So what have you read, seen, or heard? I'm sure they read, seen, or heard a lot of things about the case, but when you go to summarize it, you're just saying a quick summary. Just that I have read and seen on the news and newspapers, the trial will be next year. Just the basics of what happened and that he ended the life of 4 students. I read articles about the case, the things that come up online. The case has been getting delayed on television. That was their answer. Mostly what's been on the news and social media that he ended the lives of 4 people. I remember the general details that are being reported in the news. Basically, I know that particulars in some of the various things that have happened around the way. I have avoided a lot of the talk about it. Okay, that person doesn't want anything to do with it. Just what I read in the paper, same as everyone else. So how do we know what everyone else has read in the paper? I am aware of the homicides. I saw all the reports about this case on the news and in the local newspapers. I just saw and heard the basics. What are the basics? What are those basics? I heard on the radio. What did you hear? What was in the newspaper? Yeah, what was in the newspaper? I haven't heard anything new, just what I've heard and seen on the news. The rest is just rumors. So basically, yeah, you get the point. Um, and that is on average 4.9 items that these people have encountered. All right, so the inability to provide a full account of everything a juror knows about a case puts the defendant in an untenable position. Counsel must choose to either rely on an open ended question known to generate incomplete recall, or must or ask media specific recognition questions which are more diagnostic but risk exposing prospective jurors to extrajudicial information that they may not be familiar with. Exactly. And you might be telling them something in your question or your media fact that you might be telling them something that's actually inaccurate to the case, but because they're hearing it in this survey, they might be thinking, "Oh, it's a truth," you know. Prospective jurors' inabilities to recall the full extent of their exposure to pretrial publicity can undermine the value of voir dire as a corrective measure for identifying and ferreting out bias in high profile cases. If jurors are unable to fully recall from memory their detailed knowledge about a case when asked an open-ended question, it makes it difficult for counsel to effectively exercise challenges. The problem is exacerbated when there is extensive reporting around inadmissible content or disputed facts. Incomplete recall also poses a problem for the trial court when exercising its discretion to weigh prospective jurors' self reports about their ability to be fair and impartial and rule on cause challenges. This predicament is compounded by research, which suggests that professions of impartiality should not always be taken at face value. Part of the challenge media coverage presents surrounds jurors' efforts to guess how exposure to pretrial publicity may affect their evaluations of the evidence. Given the difficulties that such a guess poses, it is not surprising that claims of impartiality in high profile cases have been shown to be unreliable. A study on the prejudicial impact of pretrial publicity found that 62% of jury eligible residents said that they could be fair and impartial and decide the case solely on the basis of the evidence presented. However, only 39% said that they could put knowledge of the media out of his or her mind. Okay. Another obstacle is the well documented tendency for individuals to respond in a manner that will be viewed favorably by others, which has been coined the social desirability effect. This phenomenon has been researched and found in a multitude of disciplinary settings, including the courtroom. Socially desirable responses are more likely to occur. Like I said, you want to give them the answers that they want. Like, no, I haven't been, no, I have no prejudice against drunk drivers. Not at all. Okay, so yeah, you get the point. All right, you want to give the answer that you think people want. to hear, especially the people like lawyers and judges, the people in it's their turf. You're not in your own home court, so it's their advantage. And you don't, you're in a very awkward court is an awkward place to be in the first place. Just entering the court itself, you feel awkward unless you are someone who belongs there, like a judge or an attorney. It's just an awkward thing to go to court most of the time. So yeah, your um demeanor is probably going to be in your affect. You're going to want to please the attorneys. You're going to want to please the judge. So you're going to want to give answers that are socially desirable. So, social desirable responses are more likely to occur when individuals become focused on the public aspects of themselves. Public awareness of oneself can become particularly salient in a courtroom setting where prospective jurors are asked questions by an authority figure in front of a public audience. Exactly. Jones, for example, reported that participants appeared to alter their answers to reflect what they thought a judge wanted to hear rather than what they actually thought. When potential jurors learn through the jury selection process that the law requires them to be fair and impartial, there is a risk that they will overstate their ability to set aside their knowledge and beliefs in order to create a favorable public impression. Also, referred to as a response bias and demand characteristics, the effect causes the juror or the interviewee to pick up the subtle and overt clues as to what a lawyer or judge interviewer wants to hear. During the voir dire, a clear, strong message is often sent to prospective jurors. Good jurors are not supposed to have prejudicial information or biases about the case. If they do, then they should set them aside and decide the case solely on the law and the evidence presented in court. When this is established, many prospective jurors will adjust their public statements to meet to these courtroom norms. Exactly. The social desirability effect is found even in instances when the jury pool has been exposed to extreme forms of prejudicial media coverage. In Rideau, the jury pool was exposed to a taped 20-minute interview in the jail between the defendant and the sheriff. In the interrogation, the defendant confessed to the homicide of three people during a bank robbery. A soundtrack was added to the recording, and the interview aired 3 times on television within a few months leading up to trial. Dog, I don't. He keeps smacking his paw on the floor. I think he's sleeping, but I'm not sure because he's like doing it in a weird. Anyways, in Rideau, the jury pool was exposed to a taped 20-minute interview. In the interrogation, the defendant confessed to the homicide of three people during a bank robbery. A soundtrack was added. It was played a few months leading up to trial. 3 of the 12 seated jurors had seen the televised interrogation. Despite the highly prejudicial nature of such a sensational televised confession, all 3 jurors told the court during voir dire that they could lay aside any opinion, give the defendant the presumption of innocence as provided by law, base their decision solely upon the evidence, and apply the law as given by the court. Chief Justice Hughes offered this honest view of the world nearly 90 years ago in the United States versus Wood. Impartiality is not a technical conception, it is a state of mind. A trial court's decision whether a juror possessed this mental attitude of appropriate indifference must be reviewed in the totality of circumstances. It is not limited to the juror's response to a magic question. In Irwin versus Dow, the court ruled no doubt each juror was sincere when he said that he would be fair and impartial to petitioner, but the psychological impact requiring such a declaration before one's fellows is often its father. Where so many times admitted prejudice, such a statement of impartiality can be given little weight. As one of the jurors put it, you can't forget what you hear and see. With a life at stake, it is not requiring too much that the petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion and by he already put this in here. So the set aside question has also been shown in the social science literature to be leading increases social desirable responses and lacks validity, i.e., not correlated with other measures of bias. Research has demonstrated that answers to the set aside question often conflict with responses to other measures of bias. For example, Moran and Cutler found that 62% of jury eligible residents in a high profile case said that they would be fair and impartial and decide the case solely on the basis of the evidence presented. However, only 39% said that they could put knowledge of the media out of his or her mind. They also found that subjective estimates of the ability to be fair and impartial was not related to case knowledge. Sue, Smith, and Pedroza found participants who had been exposed to negative pretrial publicity and reported that they could render a fair and impartial verdict were just as likely to convict compared to their counterparts in a control group who had read neutral pretrial publicity and also reported that they could be fair and impartial. So just because you think you can be fair and impartial basically mean like this survey is saying just because you think you can doesn't mean you can. My own research also demonstrates the unreliability of the set aside question. A 2020 study presented at the American Psychology Law and Society annual conference found that prospective jurors profess that they can be fair and impartial even in the most extreme circumstances. Participants were recruited from a Facebook group dedicated to a popular miniseries called The Jinx. Oh, I saw that. I watched that. It's a good series. And they just came out with a second series or second season of The Jinx after Robert Durst was arrested and they followed him before he lost his life in prison. All right, so the documentary is about Robert Durst, a real estate mogul in New York who had been associated with a string of homicides. And he, not just a real estate mogul, but I believe he was like a rich dude too. So Durst was arrested and charged with homicide shortly after the documentary aired um, on Max, formerly known as HBO Max. The miniseries included many highly prejudicial and potentially inadmissible allegations and details. The documentary also captured a confession that was unintentionally recorded while Durst was in the bathroom. People who publicly posted highly prejudicial opinions on the Facebook page were recruited for the study. For example, one participant posted, "This is the true vision of a sociopath. I am physically ill over the conclusion. I am beside myself. I was overjoyed at the news that he was arrested." Approximately 92% of participants reported that Durst was guilty, and 77% reported that he would have a difficult time convincing them that he was not guilty in his upcoming trial. In addition, participants were familiar with multiple prejudicial media items from the documentary, including that Durst, one, was a suspect in his wife's disappearance, 96%, was a suspect in several other homicide investigations, 92%, and had been tried in Texas for homicide, 92%, and had allegedly confessed, 100% thought that. He was tried in Texas for a homicide, and for some crazy reason, he was found not guilty. And then he went on, and I don't know what he did from there, but um, then he did the documentary and got himself arrested. I need to sit differently because my hips are hurting. Give me 1 second. Hold on. All right, that's better. Okay, so let's continue on. And we're almost done. We're almost done with this report. This is Brian Edelman's report, and I told you it was Dr. Armani's report, but it's not. I was wrong. This is Dr. Edelman's report, and or Brian Edelman's report. He's the expert in the um, pretrial surveys and things like that. So there is a report attached. We're not going to go through it, but there is a report later on in here, which you can see. And there's vitae, curriculum vitaes or resumes. Here's the survey. So I'm definitely going to give you guys the link for this, and you can look through the survey yourself. So here's some media coverage. So media exposure in Latah County, population 40,000, makes up a total of 36.13% of the total media coverage in Idaho. Latah County represents 2.75 of the population of Idaho. And the volume of media coverage versus the rest of Idaho. Holy cow. Same thing. Okay, but this is Ada County. So 34% versus 26%, which is a lot better versus this. Ay, ay, ay. Volume of media coverage. We're going to go back and look at the conclusion in a minute, but I just wanted to go through the pie charts with you before I ran out of time. All right, so volume of media coverage, Ada, Bannock, Canyon, and Latah County versus the rest of Idaho. So the rest of Idaho's in the gray, Latah's blue, Ada's red, Bannock is this yellow, and Canyon is green. So that's the volume of media coverage. Now we've got opportunities to be seen per person. I'm not going to go over all the stats. You guys can come and look at these on your own if you'd like. Volume of media coverage over time, Latah and Ada counties. So which one's which? Oh, Ada County is the red line and Latah is this, I guess it's blue, but I think it looks more like black line. Um, you can see bigger spikes with Latah, obviously. Here is volume of media coverage over time. And you can also see the spikes. So, yeah, there you go. All right, so those were the pie charts that they put together, which I promised to share with you. Let's finish this up. We're almost done. We were just talking about the jinx. Participants were read an instruction drafted from the transcript from a high profile case. The introduction mentioned that Durst was entitled to a fair and impartial trial. The burden of proof was on the prosecution to prove that he was guilty beyond a reasonable doubt. Participants were also told that the law requires them to set aside any biases and opinions that they had and decide the case solely on the evidence in the courtroom. Participants were then asked if they could be a fair and impartial juror and decide the case solely on the basis of the evidence of law required. Even though these participants had been exposed to a prejudicial mini-series with multiple inadmissible prejudicial details from the documentary, made negative comment about the defendant publicly, believed that Durst was guilty, and indicated that he would have a difficult time convincing them otherwise. 81% reported that they could be fair and impartial when asked an open-ended question. Their responses mirrored what they had heard from the introduction. For example, the participant who described the defendant as a true vision of a sociopath, reported that he could definitely be fair and impartial, and explained, I could start from the beginning and listen to the information presented and follow the directions and wipe out everything I know. I would need to be convinced beyond a shadow of a doubt. These findings are consistent with the body of social science literature on the efficacy of the set aside question. Even in the most extreme circumstances, prospective jurors provide the socially desirable response. Wow. Accordingly, a juror's professed ability to be fair and impartial should be taken at face value in cases where there is substantial prejudicial pretrial publicity. This is less of an issue when dealing with the tangential experiences, limited case knowledge, and general attitudes that jurors typically bring with them into the courtroom in most cases, uh, like medical malpractice, DUI. There is little evidence, however, to suggest that individuals can forget or dissociate themselves from specific attitudes, emotions, and beliefs about the defendant in case developed from exposure to media coverage. Like, for instance, you're not going to be a member of MAD, Mothers Against Drunk Driving, in a drunk driving case. It's just you've got those specific attitudes and emotions, and you don't belong on a jury there. And or you shouldn't be. Even if you say, I can put my feelings aside. No, no, you can't. You probably cannot. That's my dog making noise. Sorry. All right, so we're finally at the conclusion of Brian Edelman's report. So let's get through this here, and then I will send you guys on your way to look through this on your own. All right, so it is my opinion that the residents in Latah County have been exposed to extensive prejudicial pretrial publicity and social media surrounding the murders of Kaylee Gonzalez, Madison Mogan, Zena Kernodle, and Ethan Chapin. The media saturated the jury pool with potential trial evidence and details, some of which proved to be false or misleading. These homicides sent shockwaves through the local community and generated widespread panic during the 6-week search for the unaliver. With limited information made available by investigators, rumors and misinformation proliferated through informal communication channels and social media platforms about the crime and the unaliver. Residents remained on high alert and feared that the unaliver could strike again. A large number of students went home for the Thanksgiving break and did not return. Despite efforts by the court to curb the flow of prejudicial pretrial publicity, the survey data indicate that the coverage has had an impact on a jury pool and undermined the presumption of innocence. Approximately 98% of the survey respondents were familiar with the case. In addition, community members have more than just a passing familiarity with this case. 68% of survey respondents reported that they have followed the case somewhat or very closely, with 29% falling into the latter category. In addition, 79% of survey respondents recognized at least 5 of 9 media items that were tested in the survey, and 52% knew 7 or more. I don't want to go through all the statistics again because we've been through it. These findings are particularly concerning given that the media items, which came from the probable cause affidavit released to the media, and who writes the probable cause affidavit? The law enforcement does. So, and it was released by the prosecution. It was unsealed. Boyfriend's home. So dogs are all getting loud. All right, sorry. So, these findings are particularly concerning. They were taken off the probable cause affidavit, which was unsealed and released to the media, and were significantly related to prejudgment. This puts the defendant at a distinct disadvantage at the start of trial. Many of the incriminating details widely reported are in dispute, including the claim that Kohberger's vehicle was placed near the crime scene by video footage and cell tower data. After these details were mentioned repeatedly in the coverage for over 16 months, the prosecution stated during a hearing that several of them were false or potentially inadmissible. Within this climate, the burden of proof has shifted to the defendant. Kohberger must change jurors' pre existing opinions regarding the evidence against him, which have developed from extensive exposure to biased media coverage. Several rumors have proliferated throughout Latah County. For example, survey respondents reported that Kohberger had a bad history with women, was responsible for the homicides, bragged about committing the perfect homicide, and was acting strange after the crime occurred. The media also shared posts from his social media accounts which reinforced negative opinions of the defendant. Other survey respondents reported that Kohberger was obsessed with one of the victims, had dated her, tracked her location, and been in her house in the past. We don't have proof of any of that. There was also speculation about illegal substances, other suspects involved, an online business that was um, adult in nature, and parties at the victim's house. Many Latah County prospective jurors exposed to prejudicial media coverage hold a presumption of guilt. We're not going to go over all the statistics again, but they do. So, yeah, 51% of survey respondents reported that Kohberger would have a difficult time convincing them that he was not guilty. That's pretty awful. All right. So Latah is the 11th largest county in Idaho with just 32,000 residents over the age of 18. And I don't want to go through all the statistics again because we've done it. But these homicides have devastated the small community and shattered residents' sense of safety. The survey data provide insight into the extent of personal connections among Latah County residents to Moscow, University of Idaho, and these homicides. Approximately 88% of those familiar with the case have talked about it or heard others talking about it in person or online. In addition, 78% of survey respondents lived in Moscow or knew someone who did. A sizable percentage of the prospective jury pool was also connected to the homicide investigation. Approximately 22% of the Latah County survey respondents are employed or know someone employed by law enforcement there. I mean, this is just insane. Latah County residents lived in a perpetual state of panic during the search for the unaliver. Many survey respondents reported that they started locking their doors for the first time. Just lock your doors. Just lock them, period. Keep them locked. And parents feared for their children's lives. More than half of survey respondents reported that they or someone they know experienced higher levels of stress, anxiety, or fear during the manhunt. The number increased to 63% for Moscow residents. Overall, these findings are particularly concerning given the limitations of voir dire as a tool for assessing the full extent of prospective jurors' case knowledge in high profile cases. Consistent with the research literature, survey respondents offered incomplete recall when asked the common open-ended questions. What what have you read, seen, or heard about the case? Most survey respondents later recognized at least one additional media item that they failed to report in their open-ended answer and recognized an average of 4.9 additional media items. Jeez. For example, only 3% of survey respondents mentioned that Bryan Kohberger had stalked one of the victims when describing it. However, 45% remembered that item. All right, so jurors' inability to fully recall what they know about a high profile case undermines the value of voir dire as a tool for ferreting out bias. If jurors are unable to fully disclose what they have read, seen, or heard, then neither the court nor defense counsel can properly weigh professions of impartiality. So, self professions of, I profess that I'm impartial and can look at this case um, without any kind of bias. That's what they're saying. So anyone that is saying that, you can't just take people at their word saying that they are going to be impartial. The comparison survey also found significant case recognition and bias in Ada Canyon and Bannock counties. However, there were important differences between Latah County ah, and the comparison venues. Ada County's population is more than 12 times larger than the Latah County. And this is all, again, statistics that we've already been through. Finally, Ada County community members did not suffer the levels of emotional distress. Yes, okay. So, in conclusion, given the nature of the pretrial publicity, its negative impact on the Latah County jury pool, and the small size of the county, I believe there is a reasonable likelihood that the presumption of innocence has been undermined and shifted to a presumption of guilt. As such, remedial measures are necessary to protect the defendant's constitutional rights to a fair and impartial trial. Based on these findings, it is my opinion that a change of venue would be an appropriate prophylactic measure to mitigate the prejudicial impact of pretrial publicity surrounding the case. I declare under penalty of perjury under the laws of the state of Illinois, state of California, that the foregoing facts are true and correct except as to facts stated upon information and belief, which facts I believe to be true. And that is signed Bryan Edelman. And then he gives his curriculum vitae. I'm not gonna, I don't want to dox him. And then, but it's public. All right, so this is the actual survey. Hello, my name is from blah county. We are not selling anything. This is not a political poll. We're doing a public opinion survey among local residents to obtain opinions about an upcoming jury trial. Your cooperation is very important because your household was selected at random by computer as being representative of your county. Again, we're not selling anything. Would you like to do this survey? Okay, fine. Um, does the respondent have a reasonable working knowledge of English? Yes. First, do you live in Latah County? Answer yes, no, or refuse to answer. And you're only looking for people in Latah County, so you discontinue if they're not. Have I reached you on your cell phone or landline? Is the next question. Are you a citizen who is 18 years or older? So you ask yes, no, or refused, who with an Idaho driver's license and um, a Latah County address. Are you a U.S. citizen who is under 18 and registered to vote in Latah? Yes, no, refused. Are you in a place where, well, you have to be registered in order to be on jury duty. So if you're a no, then discontinue survey. So moving on. So only the people that are 18 and older and registered to vote in Latah County and have a residence in Latah County and an ID in the state of Idaho. All right. So, are you in a place where you can safely talk on the phone and answer my questions? Yes or no? When is a safe time to call you back? If they said no, before I begin asking your questions, I'd like you to know that there are no right or wrong answers and that you are free to respond with a don't know or no opinion answer to any question. All of your questions will remain confidential. And I'm just going to go through this quickly. I'm not going to go through, but here are your answers. Well, first, hold on. Question. Now I'd like to read you a few statements about the criminal justice system. Please tell me whether you strongly agree, somewhat disagree, or strongly disagree with the following statements. If the government brings someone to trial, that person is probably guilty. And then they've got all these options. Next, it is better for society to let some guilty people go free than to risk convicting an innocent person. Last one, even the worst criminal could be considered for mercy, meaning like even Ted Bundy, you could bestow mercy on him somehow. Now I'd like to ask you about an upcoming jury trial in Latah County back in 2022. Four students attending the University of Idaho in Moscow were stabbed to um, to their loss of life in their homes. I try not to say those trigger words, and then it always sounds like I'm stupid. So I apologize. After a month later, Bryan Kohberger was arrested and charged with homicide. Have you read, seen, or heard anything about this case? And yes, no, don't know, or refused, and A. Bryan Kohberger was arrested at his parents' home in Pennsylvania. Have you read, seen, or heard about that? Yes or no, or whatever, what don't know. Next question. Based on what you have read, seen, or heard about this case, do you believe Bryan Kohberger is definitely guilty, probably not guilty, or definitely not guilty? Given what you've read, seen, or heard about the case, would Bryan Kohberger have a difficult time convincing you that he is not, repeat, is not guilty? Yes, no, don't know, no opinion, refused. How closely have you followed this case? Would you say very closely, somewhat closely, not too closely, or not at all? What have you read, seen, or heard about this case? So that's an open-ended one where they're only going to give you about one or two items, and then you're going to ask them all these other things, and they're going to go, oh, yeah, I heard all those things. What rumors or theories, if any, have you heard about these um, homicides, Bryan Kohberger or the victims? There's been so many rumors that have just run rampant. So it's kind of good to hear what all the rumors are, too. This is a good way for feedback of what other rumors might be out there that you aren't aware of as a defense team for him. So, what are your thoughts and feelings about Bryan Kohberger, the victims, and this case? What three words do you believe best describe Bryan Kohberger? What is your opinion of Bryan Kohberger? Is it very positive, very somewhat negative, or very negative? Or you could say no opinion, don't know, or refuse to answer. How did these homicides impact your community? That's another open-ended one. Next, the prosecution is seeking the DP for Bryan Kohberger. If the jury finds him guilty of first-degree homicide, it must then decide on whether to sentence him to the DP or to life without the possibility of parole. Which sentence do you believe the jury should select? The DP or life without possibility of parole? Other, and then what's their response? So maybe I'll say, um, you know what, I think he deserves 60 years for each person or something. I don't know, just something random. And that's what that person believes. No opinion and don't no refused. All right, so given what you have read, seen, or heard about the case, would Bryan Kohberger have a difficult time convincing you that he should receive life without the possibility of parole instead of the DP? Yes, no, no opinion, or refuse. Don't know. How do you believe residents in Ada County would react if the jury found Bryan Kohberger to be not guilty? What concerns, if any, would you have about serving as a juror in this case? That's a good question. Media coming at you, probably, and maybe even public pressure to get it right, and potentially public pressure, uh, people from the public that might be pressuring you, jury tampering, whatnot. I'm always worried about that. I'm surprised it doesn't happen more, or we don't hear about it more. As you may know, the media have reported a number of things about this case. Some people may remember some things, while others may remember other things. We're interested in what you may remember, even if you already told me in one of the previous questions. So tell me all the things you know. Then, have you read, seen, or heard Bryan Kohberger was arrested at the parents' home? Oh, this is for only those who answered yes on question two. Everyone who answered yes on question two, blah, blah, blah. Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Have you read, seen, or heard if DNA found on the knife sheath was later matched to Bryan Kohberger? Have you read, seen, or heard if Bryan Kohberger owns the same type of car recorded on video driving in the neighborhood where the homicides occurred? Have you read, seen, or heard if cell phone tower data shows that Bryan Kohberger made several trips near the victim's home in the months prior to the homicides? Have you read, seen, or heard if university students in Moscow and their parents lived in fear until Bryan was arrested? Have you read, seen, or heard if Bryan said that he was out driving all night on the night of the homicides? Driving alone, sorry. Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims and had followed one of the victims on social media? Have you talked about the case with your family, friends, or coworkers, or discussed it online? Have you ever heard others talking about the case in person online? Have you seen anything about the case on the homicides on Facebook, TikTok, Twitter, or where's YouTube? Or other social media sites? Have you wished any episodes, have you watched any episodes or shows covering the Moscow homicides, for example, on Netflix, Paramount, or Dateline? Have you joined any groups on social media that talk about the case? For example, the University of Idaho Homicide Discussion Facebook group or Reddit, which is what I'm on. I'm on the Justice for Bryant Kohberger page. They've got a lot of good stuff. Have you listened to any true crime podcasts or watched any shows on YouTube that cover the case? For example, the King Road Ki double Ellings. Did you, a family member, or someone you know live in Moscow when the homicides happened? Are you or a family member a student or employee of University of Idaho? Have you ever visited or walked by the home where the homicides occurred? Did you experience higher levels of stress, anxiety, or fear during the search for the person responsible for these homicides? Can you tell me about that? Did someone you know experience higher levels of stress, anxiety, or fear during the search for the person responsible? Can you tell me about that? Did you or someone you know work for any law enforcement agency? Finally, I have a couple of more questions. To be sure, we have included all groups in this survey. All of your answers will remain confidential. First, how often do you read a hard copy or online version of a newspaper? Would you say you read it every day, several times a week, or twice a week, less often than once a week, or never? What newspapers do you read? I am interested in both local and out of town papers. And they list a few papers here. And do you read any of the other papers? Any other papers? Record up to 4 newspapers. It says instruction: do not read the list of newspapers to respondents. Oh, okay, so don't do that. um, all right, so how often do you listen to local news on the radio or watch it on television? Do you listen to or watch local news every day, several times a week, once or twice a week, less often than once a week or never? How often do you see local news or news related updates online or on social media? What city or town do you live in or nearest? So it's kind of like the town breakdowns from, there's 10 people from Moscow who did the survey. Could you please tell us how old you are? And then, regardless of race, are you okay? Who cares about this and this? So, just basic general questions. So, that's it. That's all I have for you for this episode. I don't think we're going to get into this Edelman one. Where is it? I'm interested in reading it, but this is another Scott Sundby is another expert for the defense. So they provided a lot of curriculum vitaes and stuff for this as attachments. So you don't need to look through all of these. This is the other report I was talking about, which I said the wrong person's name. This is Dr. Amani L. Alali, PhD, um, who also did a report for Bryan Kohberger. It's a very long one, so I'm not sure if I wanted to really read it to you guys. So we've already been through 4 parts, and I think you guys get the point. Um, and this is more information about bias and, how jurors and people become biased. So it's really good information. I'll let that you guys read that on your own if you would like, or if you really want me to read it, put it in the comments below, and I will do another episode, a part 5, to at least get through some of it. So it goes through like stuff about confirmation bias, judgments of guilt across communities, things like cognitive dissonance, specific things like that, kind of like the psychological stuff. Um, and he goes into more of those things like social desirability and whatnot. So if you guys are interested, let me know. But otherwise, I'm going to call this one done. 4 parts. We did it. Um, yeah, let me know what you guys think in the comments below about the change of venue. Do you think Bryan Kohberger should get a change of venue? Should Judge Judge John Judge, should he grant this motion for change of venue? I think they've done a very, very thorough job in putting together their response. So I almost find it like impossible when I see a really, really good motion and I'm like, oh, they've got, this is a shoe-in, but then you never know what a judge or a jury is going to say or do. So, on that note, let me know what you think Judge is going to do, and I will see you guys in the next one. Thank you so much for watching. Take care. I'm out of here. Bye, guys.